have prepared a short note, my lord, giving a gist of all these 47 FIRs which have been lodged. The issue.
Where is the state?
We have served copies, my lord.
Yes. Ready. Start.
Yes, my lord. Yes, state is here. Now, my lord, challenge here.
Other matter also, because I was not here actually.
Yes.
The challenge here is to these 47 FIRs which have been lodged within a span of 1 month and 4 days against the petitioners. Large number of these FIRs are open-ended. They just say people from one political party come. They have done this, they have done that. They have assaulted people and they have said that if you vote for a particular party, then you will have to face the consequences. And the mob, the words used are open-ended. They can rope in anybody. In some of them, 7, 8 of them, petitioner number 1, who is the current leader of opposition, because there is an interim order of this court that no direct FIR can be lodged against him, they have said it has been done under the influence of petitioner number 1. So even that fact is kept open. But the most surprising, if not shocking part of it is, out of these 47 FIRs, 34 have been scribed by the same person. The complainants are different, but the scribe of 34 of these 47 FIRs is the same. Just for example, please kindly see the paper book at page 87.
I see there are many private respondents over here. Who are
These
they?
are the complainants.
All are complainants.
What happens, my lord, according to me, from what I can make out from reading the FIR, somebody in one office or one place is scribing these FIRs.
Yes.
In the name of different people. Because the narrative is common. It is one man's language. So in the name of different people, these FIRs are being scribed and then they are being lodged in the same police station.
And is the content same?
Content is more or less the same.
Alright.
The intent is the same.
Okay.
In some, it is a little different. We have made a gist of the entire content. I'm going to read it. But kindly see the first FIR at page 83. Kindly see page 83, where the first FIR starts.
Yes.
Now kindly come to page 87. The
Yes.
original complaint in the kindly come to page 87. This shows complete. This is a complete misuse of the process.
Yes.
And all complaints are in one police. Just see at the bottom, my lord, writer, left hand side at the bottom. Your lordship got that word writer. Now it says Bashir Ahmed, son of
Jonathan Bhutia, yes.
Shamalan something. Bashir Ahmed. Now your lordship may kindly come straight away to page 92. Just 92. The second FIR. Just see at the bottom again at page 92. Bottom left. Writer Bashir Ahmed, son of so-and-so, same mobile number. Now kindly come to page 108. I can go on, Lord. I'll just show 2 or 3. Your lordship will take it. Just see 108. In the left, writer Bashir Ahmed, son of so-and-so, same mobile number. There are 34 of these 47 FIRs are scribed by this man in his own handwriting, and he puts name of different complainants on the top. Now kindly have the gist of the FIRs, my lord. This short note which I have given to your lordships. Kindly have serial number 2, just to have a sort of deal of what the complaint. Just kindly see page 3, serial number 2. Now petitioner number 5 is named in the FIR. It's a written complaint. Complainant is Dev Kumar Roy, president of the Trinamool Congress Party. So he is the complainant. He is the so-called complainant, but he hasn't written this complaint because somebody else has scribed it. He has signed it only. FIR named accused persons on 11th May, being a Saturday, around 12 noon, suddenly attacked members of the complainant, threatened to take his life. Complainant being president, so-and-so. That's the FIR. Now kindly see the next FIR, my lord, serial number 3. Now at 3 first note that it is open-ended. 1 or 2 people are named, but then it is and others. Now kindly see page 4. Allegation. The FIR named accused persons are notorious in nature. Page 4. The FIR named accused persons are notorious in nature. Past few elections under the leadership of the FIR named accused 1 and 16, other FIR named persons are involved in several antisocial activities like threatening, kidnapping, abducting, destructing of houses, beating people, molesting women, have several cases. In these circumstances, on 20th March, Wednesday, under the leadership of FIR named accused 1, that is Suvendu Adhikari, there cannot be an FIR against him. There is an interim order without leave of the court. And 16, the other FIR named accused attacked so-and-so and his family. He belonged only because he belonged to the ruling dispensation. Gurprada Das was abducted, thrown to the road with intention to kill him. He was attacked with weapons on his head to split in half. He was attacked all over the body. Gurprada was in terrible conditions that could have led to his death, etc. Furthermore, accused 1 and 16 went to the house and tortured the woman. They threatened they will kill the entire family. Even the children were slapped. Then last 3 lines. With the assurance that they will never continue supporting Trinamool Congress, the miscreants left the place. It is mentioned that miscreants belong and are goons from the BJP. Now, therefore, open complete. Now, kindly see the next serial number 4. Just kindly read only the last 5. This is also open-ended. Just see the first line. Complainant is an active lady worker belonging to the ruling dispensation. Persons are notorious and goons of the BJP. Now kindly read the last 3 lines. When neighbors gathered, they came out of the house, destroyed the flower pots, threatened not to give vote. If the complainant goes, then we'll bury on the ground so-and-so. Now kindly see from serial number 10 onwards. I can read all, but just to give a serial number 8 also, if your lordship will see. It's more, just see serial number 8. It's open-ended. Again, at 9 a.m., the FIR other accused person surrounded the house of the complainant, destroyed the house, assaulted the wife, outraged her modesty. Complainant and wife came out of the so-and-so. They destroyed the motorbike. He tried to rescue his wife, assaulted. Then local people rushed to the spots. The accused threatened the complainant. Now, all open-ended. Anybody can be rounded up and picked up like this. Now come to serial number 10. It's very interesting. Serial number 10. Now this FIR again is a written complaint, and complainant is what Anita Mondal. On 23rd May at 11:40-12 at night, shop of the complainant in Bhaturia, FIR named accused persons are miscreants and goons. Under the influence of Suvendu Adhikari and Meghna Pal, miscreants went to the complainant's shop, broke open the door with iron rod and hammer, etc., threw cylinder in the pond, took all articles, could hear the miscreants destroy her shop. As she was scared for her life, she was standing far away. They were abusing the complainant using slangs, etc. The complainant suffered a loss of 2,50,000. Now kindly see serial number 12. 12, 13, 14. 12. Now, this is a written complaint. Complainant is somebody else. But all these are being scribed by the same person. On 23rd May at 7 in the morning, in various booths, FIR name accused persons are influential and powerful goons. Under the influence of Meghna Pal and Suvendu Adhikari, FIR so-and-so under his leadership and other persons carrying sharp weapons went to the house of the people in Trinamool Congress located within the areas of the booth on bikes and attached their houses and abused them. Accused persons looted and destroyed their houses, beat up 6 children, etc. Then, my lord, serial number 13. At 7:30 in the morning on the complainant's own house, FIR named accused persons, influential, powerful goons, on the date and time suddenly came to the complainant's house, attacked her by physically abusing her, tried to kill her by strangling her. Person started destroying. So this attacked her, tried to kill her by. This is common. This if your lordship reads the vernacular, the expression is common in all these 30 and odd FIRs. Yes. At 141 again, this written complaint serial number 13 is drafted by the same individual, whose names I have just read. Under these circumstances, just the last line, under these circumstances, the complainant and her family and supporters of TMC are not feeling safe. Then next, serial number 14. Accused persons came on the complainant's house on bikes, attacked her, they verbally abused her, accused tried to molest by opening their clothes, etc. The accused persons are doing this under the influence of Suvendu Adhikari. Now the question is, Lord, the reason why we have come is, the petitioners have come is, that there has to be some proper investigation by an impartial agency that what is going on here. These 47 complaints in 5 weeks, scribed by the same individual, and all open-ended. Anybody from a particular party can be picked up and put behind bars. So actually, it needs to be looked into by your lordships that what actually is happening. Is there any truth in any of them? Or are these all, because ultimately, my lord, if they are all malicious and it is being done in one police station, then what kind of investigation affair can we expect here? It's just to round up whoever they want under the guise of these 47 complaints. Just anybody can be rounded up. Now I can read further, my lord. Just kindly see serial number 17 now.
No, it's more or less the same.
Yes, it's the same. No, but just see all Lok Sabha election, all one party versus other party. Just kindly see page 15, serial number 17. The complaints have stated that FIR named accused persons are influential under Lok Sabha elections, have threatened that he will be killed and leave the locality which the complainant and other members used to spend their daily life in a disturbed, frightening way. On the above mentioned date after victory in Lok Sabha, they have intentionally gathered for a rally with firearms, etc. So these are, in this way, my lord, anybody's life and liberty can be put to danger, my lord. Anybody's life and liberty can be threatened and taken away, my lord. The liberty can be taken away.
What is your prayer?
My lord, my prayer, just kindly now see the prayer. I have asked for quashing in the first instance, but more importantly, I have asked, 1 minute, at serial number E, if your lordship will have, at page 52. Issue a writ in the nature of mandamus to form an independent and impartial agency for fit and proper to form special investigation team headed by a retired Honorable Justice of the High Court to conduct an inquiry and come to a finding as to why successive FIRs were registered from 8th May to 12th June against the petitioners number 2 to 10, other members and supporters of the party in opposition. That's the whole point. This is targeting a particular party, and all these 47 FIRs cover the whole spectrum where anybody can be sort of rounded off and his liberty taken away. And ultimately what they are targeting is petitioner number 1, because it will come, the statements will be recorded. If what I am saying is right, if all this is an exercise which is being conducted in a designed manner, then the design statements will come. So ultimately this is a very serious issue affecting my liberty also, Murad. And Murad, I can cite a series of orders in my own petition. This happened also in 2021 when I defeated the present incumbent chief minister in Nandigram election. At that point of time also, series of FIRs like this were registered against. I had come to challenge those. There are a large number of orders. I just want to show one of those orders to your lordships. Just pass on. Can you pass on the compilation? Just one of those orders. We have a whole compilation of those orders. But just kindly have one order at page 30. This is an interim order dated 6 September 2021, which they have taken to the Supreme Court on 3 or 4 different occasions. But the order has sustained and not been disturbed. This was in relation to 6, kindly at page 30.
Yes.
I'm just going to read this. The writ petitioner complains of abuse of state and police machinery. The writ petitioner here is petitioner number 1 also. By ruling dispensation in registering 6 FIRs against him in 4 different police stations, claiming violation of rights under Article 21. Writ petitioner seeks intervention of the court under Article 226 of the criminal proceedings being filed against him. Alternatively, the petitioner seeks transfer of investigation in the said 6 FIRs. Writ petitioner is a member of the Legislative Assembly, leader of opposition. Until December 2020, petitioner was member of the political party which was in power. Since 19 December, he joined rival political party, contested elections. While petitioner was member of the current ruling dispensation, he was a transport minister in the state cabinet and was also in charge of Department of Irrigation and Waterworks. Prior thereto, he was a member of parliament. According to the council, victimization and harassment by the state had begun immediately after the petitioner changed political allegiance in December 20 and intensified after assembly elections in May 21. The state fired the first salvo by removing a security cover, etc. My lord, I can leave these few pages, my lord. Your lordship may then straight away come to where the findings are. Just kindly also glance over page 37, my lord. where the learned Advocate General had raised a demur and relied on Pepsi, etc., that this court should not entertain the petition. All that was considered by the court. And then Arunabh's judgment and all judgments were relied upon. And at page 41, the court then concluded, in the middle of the page, 41, in view of the above, the court is of the view that writ petition and prayers made are eminently maintainable. Then, my lord, on merits, I will leave that. I will take your lordship straight to the findings. Just kindly have page 45. Page 45.
Yes.
The observations, the above observations are prima facie. Now, this is first. The writ petition is entertained by this court in view of the prima facie satisfaction that the police of the state in series of 5 FIRs registered against the petitioner appear to have acted overzealously and maliciously for the following reasons. Now, reason A, your lordship may leave it as security. B, well over 7 and 8, and in some case, 13 consecutive FIRs have been registered against the associates since the recent assembly election. The associates of the petitioner have also changed partnership with the political party. An incident of 18 is registered as an FIR without even a preliminary inquiry as regards delay in lodging the FIR. Then, my lord, those are all on merits. But please have page 47. Very important. Page 47. The court finds substantial force in the petitioner's argument. Prima facie, there appears to be an attempt at implicating and victimizing him in criminal cases, Malafides, malice and collateral purpose in registering FIRs against the petitioner and his associates, a scheme and or a conspiracy or pattern or stratagem appear to have been devised to entrap the petitioner and his associates to ensure their incarceration and custody to embarrass them. This is the point I'm trying to make here. Now, Article 21 enshrines the most vital rights that a citizen of this country is required to be secured with. Rights under Article 21 and importance cannot be overemphasized. Rights under Article 21 are so very basic and fundamental and touch upon human rights that they are guaranteed even to non-citizens. Deprivation of such liberty is to survive the test of due process established by law. And any indication of such deprivation of liberty contrary to procedure established by law calls for immediate intervention under Article 226. The right to life and personal liberty is cardinal, above all, and completely non-negotiable. Now, next lines are very crucial. In the instant case, there is prima facie evidence before this court of abuse or misuse of state and police machinery in registering cases for investigation based on half-truths, fiction, concoctions, and non-events. A very powerful statement being made by this court, my lord. So this actually, I cannot place my case better than this observation in this case. And therefore, my lord, in the face of this, all proceedings there were stayed, my lord. There shall be stay of proceedings. Every proceeding was stayed. And the last line, the court shall obtain leave of the court before arresting the petitioner or taking any coercive action against him in any such case. Then, my lord, then this was taken to the Supreme Court also, my lord. At page 72. Where is that? Page 72. Matter was heard at great length, my lord.
Yes.
At page 72. The specially petitions under Article 136 of the Constitution arise from an interim order dated 6 September of single judge of the High Court. Single judge has permitted affidavits in opposition, etc. As on date, West Bengal are yet to file reply. The prima facie observations of the High Court at this stage are in support of the ad interim stay which has been granted. Since the High Court is seized of the proceedings and specially petitions arise from an interlocutory order, we are not inclined to exercise jurisdiction under Article 136 of the Constitution. We, however, leave it open to the petitioners to file their affidavits in opposition before the High Court. Thereafter, the High Court may either consider taking up the petition under 226 or for expeditious final disposal. In the event it is not possible to do so, then consider any application, etc. Some applications were filed, my lord, but nothing has been done Then your Lordship may kindly see page 52, where subsequently 17 more FIRs were stayed. 1 minute. Page 52 is the next order of 8th December. The writ petitioner is a leader of the opposition. He is aggrieved by state lodging 17 FIRs. So from 6-7 it became 17, now 47. So the number keeps on swelling every time in every new round. The sum and substance of the argument advanced by counsel appearing for the petitioner is that FIRs which have now reached 26 in number are an attempt to prevent the petitioner from performing any functions as a people's representatives. The said FIRs have been registered motivatedly at the instance of the ruling party. Then, my lord, I can leave those FIRs. And then page 55. The court is also required to consider as to whether, since after a restraint order was passed by the state against any coercive measures on the so-and-so, a novel way has been adopted by the ruling dispensation to choke the writ petitioner in FIRs and notices under 41A, thereby frustrating the effect of the order. By the order dated 6 September passed on the aforesaid writ petition, a series of 6 FIRs filed against the petitioner was considered. The court found that there was a scheme or a design by the ruling dispensation in the state to somehow deprive the petitioner of his liberty. Some of the FIRs were stayed. Petitioner was asked to cooperate with the investigation of others. Thereafter, about 17 FIRs have now come to be registered. Some paragraphs, I just read that order, my lord. I don't need to read it again. Page 6, if your lordship will now have. What happened in that case? It is argued that most of the aforesaid FIRs are in respect of small flimsy act alleged against the petitioner. There are threats and public speeches stated to have been made by the petitioner. Some of the speeches are stated to have hurt the sentiments of a section of citizens. There are threats and intimidation alleged to have been made while canvassing for votes. In fact, some of the complaints based on which FIRs have been registered have been described as fill in the blank FIR. The name of the complainant, age and father's name have been left blank to be filled in at random. I pause here. Now they are not doing fill in the blanks. Now they are naming people, but somehow, sometimes, my lord, something gives away the game. The gentleman who wrote it, he has autographed each FIR. He need not have done so. We would never have known. But one man has written all 34 FIRs. It's indeed shocking with respect, my lord. The name of the complaints, age and father's name have been blank. Such blank complaints appear to have been handed out casually to persons owing allegiance to the ruling dispensation. Some persons appear to have left complaints at police stations after filling in the blank at which the concerned police station have mechanically, overzealously, and in furtherance of the dictates registered FIR. The actual intended consequence of FIR is that 26 days in a month, writ petitioner would be confined in police stations to respond to notices under 41A. It is maybe necessary to refer to submissions of learned senior counsel that his client had contested the last assembly election against the present head of the dispensation and won. Personal vendetta of some person owing allegiance to the said person therefore cannot be ruled out. The reasons behind dragging one single individual and family member in such volume of complaints are argued to be irrational and unexplained. Now this is the court now speaking. This court refers to hundreds of writ petitions that have been dealt with in the last few months in respect of FIRs against various persons of offences similar to those referred to the FIRs. In most of these cases, either proceedings under 107 or 116 were drawn up and the police conducted inquiries and warned such persons. Then, my lord, the learned advocate general submissions are noticed. If your lordship will have the last para. However, that by itself cannot give a carte blanche to the state to indiscriminately register FIRs against the petitioner, mechanically or motivatedly so. This court refers to the observations made in paragraphs of the order dated 6 September set out in detail. Then the allegations for counsel of the petitioner in each of the FIRs were an attempt to frustrate the protection granted cannot be brushed aside. Then Niharika is noted. Then it is noted that indeed a writ court must be circumspect and slow to quash FIRs. However, in the peculiar facts and circumstances of the instant case, the fact that the writ petitioner is an elected representative of the people holding the post of leader of opposition, the court's mind is not free from doubt that the state police machinery, either on its own or under the influence of persons in the ruling dispensation is out to completely stall the public life and personal liberty of the petitioner, there appears to be a calculated design to deprive the liberty of the petitioner. As stated here and above, there appears to be an attempt to bypass the interim protection granted, which has been upheld by the Honorable Supreme Court. Then, my Lord, Court says, in these circumstances, this Court is of the view that each and every FIR referred to in the petition shall remain stayed. The police shall not register any more FIRs against the petitioner without the leave of this Court. The prayer for transfer of investigation shall be considered after affidavits are filed, etc., etc. This writ petition, my Lord, has been argued at great length. We have concluded for the petitioner. State has concluded. There were two complainants counsel. One has concluded. One will probably conclude on Thursday, and then rejoinder, and then that is the status of these two petitions in which these orders were passed. This order was challenged in 4 different rounds in the Supreme Court. First round is page 6. First, the state withdrew. Then they made some complainant to go. That got rejected. Then second complainant got rejected. Then the state again went. Every time this order has been upheld by the Honorable Supreme Court. So, my Lord, that in these circumstances, my Lord, shall I give the page numbers where the orders have?
Yes.
Yes. So, page 61A, first is the first round when the state went, immediately after the order was passed. On mentioning the order is taken on board, on 8 December, the following directions was issued by the single judge. Dr. Singhvi, learned senior counsel appearing on behalf of the state, submits, as a result of the blanket stay which has been issued on registration of any FIR against the respondent, the petitioner state is unable to register an FIR in respect of an incident which took place yesterday when certain deaths are alleged to have taken place in the course of distribution of blankets. Since the single judge is not available for judicial work, it has been submitted that specially petition had to be instituted before this court. Even if the single judge who passed the order is unavailable for work at Calcutta by virtue of his judicial assignment at Port Blair, petitioner has the remedy of moving the learned Chief Justice for appropriate directions. In view of the above, Dr. Singhvi, learned counsel, states he seeks to withdraw the SLP to enable the petitioner to move the Chief Justice without prejudice to his contention. It is clarified we have recorded the submissions and not expressed an opinion. Application was moved, not granted. Then the second round is at page 125. The second attempt to get this vacated, set aside, is at page 125.
Yes.
This time, my Lord, it is my respectful submission that one complainant in one of the FIRs were persuaded by the state to go and challenge this order. Now, in that also, the state SLP was dismissed. Permission to file the SLP is granted. High Court of Calcutta is in session of the proceedings. Next date of listing is 10th January. In terms of order so-and-so, petitioner would be at liberty to move the High Court for being heard in the pending proceedings. We permit the petitioner to do so. In this view, it is not appropriate to exercise jurisdiction under 136 at this stage. Petition is accordingly dismissed. Then, my Lord, third attempt is at page 110 against this order.